Beryl Howell. Remember that name. You probably know it already if you're a fan of Legal AF and an ardent watcher and listener. Senior Judge Beryl Howell used to be the chief judge of the D.C. Circuit Court. She presided over most of the things that mattered about Donald Trump's criminal prosecution. Made all the major decisions that matter, kept the receipts, presided over hundreds of Jan 6th insurrection cases. And she is not shy with her opinion. She has framed the latest battle of Donald Trump lurching from one constitutional crisis to another as one for the very soul of our democracy. It's the difference, it's the debate, if you will, between are we going to have an imperial unitary president and that model, or are we not? It is existential. We're watching it, the fight to the death at the United States Supreme Court. In one corner, Gorsuch, Kavanaugh, Alito, and Thomas. In the other, Ketanji Brown Jackson, Sotomayor, and Kagan. Where will the free radical float of Amy Coney Barrett and Chief Justice Roberts? If they move to the left, it'll kill Donald Trump's imperial dictator desires. They move to the right, we're all kind of in for it. We cover it all on an After Dark edition of Legal AF, the podcast. Take a listen.
Let's take a look at Judge Beryl Howell's ruling. And you may remember the name Judge Beryl Howell, all of our Legal AFers. She was once the presiding judge in Washington, D.C. So in all of those Trump cases, when there would be grand jury fights, it would go to Judge Beryl Howell, who would make a lot of these big, impactful rulings under seal. After her term was done, it was another federal judge that becomes the presiding judge for limited terms, but she's still obviously on the bench. Here's a ruling that she made this past week where she ordered the reinstatement of National Labor Relations Board member Gwen Wilcox. Gwen Wilcox, the first African-American female board member of the National Labor Relations Board. When Donald Trump singled her out to be fired, what he did was he created a situation on the NLRB where they couldn't have a quorum. And if they can't have a quorum, they're not able to make decisions. If they can't make decisions, unions can't be formed, labor grievances can't be decided. And so it really guts all labor enforcement. It guts the abilities of unions to form. So it's a major thing that union busting entities really wanted. And so for anybody who said, oh, well, Trump's going to be good for labor, if you still think he is, he gutted the NLRB board. There had to be litigation to get Gwen Wilcox to be ordered back. This, of course, is now going to go up, though, to the appeals and to the Supreme Court. We're going to be seeing so many Supreme Court cases in the late spring, early summer. We may have to have extra episodes of Legal AF, but in ordering that the termination unilateral of Gwen Wilcox without cause, just firing her by the Trump administration was unlawful. Judge Beryl Howell says that Donald Trump fundamentally misapprehends the role of Article 2. She goes on to say, a president who touts an image of himself as a king or a dictator, perhaps as his vision of effective leadership, fundamentally misapprehends the role under Article 2 of the U.S. Constitution. In our constitutional order, the president is tasked to be a conscientious custodian of the law, albeit an energetic one, to take care of effectuating the enumerated duties, including the laws enacted by the Congress and as interpreted by the judiciary. And then she goes on to cite the Constitution, Article 2, Section 3, that he shall take care that the laws be faithfully executed. At issue in this case is the president's insistence that he has authority to fire whomever he wants within the executive branch, overriding any congressional mandated law in his way. And then it goes on to say he can't do that. And so Congress passes laws, they're signed into law by the president, and the president has to take care that those laws go into effect. Now, if there's ambiguity in the laws, that's what executive orders are about, which set forth interpretation where there's ambiguity. But Michael Popok, where there's not ambiguity, a president can't rule by executive orders because in our country, we have a system where that's Congress's job. And then the president signs that law and effectuates it, signs the bill, makes it into a law. And that's what happens. But what Trump is trying to do is just make executive orders the law. And that's what dictators do. That's just not our system. And then, as you said before the break, you then have these right-wing people who go, well, that's the unitary executive. That's the unitary president. And I'm just saying, no, that's fundamentally another system called the dictatorship. And here you have Judge Beryl Howell, I think very neatly teeing up what the issue is going to be in the Supreme Court. She's framing this issue, I think, along the terms that I am and that you are. She's not using the language that I'm using. She's saying it more eloquently, of course. But I think she's saying, okay, Supreme Court, when this is handed to you, I'm putting you on the spot. You give your stamp of approval to King, if that's what you're going to do, or you reject King. That's why I think this order, in addition to saying that Gwen Wilcox goes back on the NLRB, which will be appealed by the Trump administration, why this order is actually so important that it sets forth that framework. Popok.
Yeah, I think there's nobody better than Senior Judge Beryl Howell to take on Donald Trump and to frame the issues going forward. People will probably recall, as you said, she not only presided over many aspects of the criminal prosecutions of Donald Trump. She's the one that ruled that lawyers for Donald Trump should be stripped, along with Donald Trump, of the attorney-client privilege, because it was more likely than not they were participating in a crime or fraud. She's the one that started off the Mar-a-Lago investigation with a subpoena, eventually became a search warrant. We know what happens there. She presided over the Rudy Giuliani defamation case, resulting in a $158 million judgment against him. She presided over many Jan 6 trials and sentencings, and she's been very outspoken about Trump as king and reining him in. In fact, about 6 months ago or so, she gave a speech, I think, to an American Bar Association meeting, and said almost what we see here. So, she's consistent with her thinking about the absolutist king and the slippery slope that we're seeing with Donald Trump. It was so jarring to MAGA that Elise Stefanik, who's now the ambassador to the UN for Trump, but was then a congressperson from New York, we're going to talk a little bit later about bar complaints, made a bar complaint about her, a judiciary complaint about her, that she had, prejudged her cases and she was political and all of that. But what she did in the first 4 pages of this decision is really masterful. When you and I saw it, we both sort of wrote at the same time, powerful. And she doesn't even talk about the case. Like, if you just got the first 4 pages of her decision, you'd be like, what is this case about? After the first 4 pages, when she's done with the historical precedent, the analysis, the role of the various entities, the Article 3 judges, the Article 2 president, the Article 1 Congress, and she stitches it all together and just totally craps all over the unitary president theory, but does remind everybody in a footnote that Donald Trump has called himself a king. We have the fake time cover that he used for that, and has said that he'll be a dictator on day one. She quotes all of that to remind everybody what we're working on. She then sets up this academic debate that is the soul of what we're going to be fighting over for the next 4 years, which is, on one side, the legal academics like Steve Calabresi, who has said in just the titles of his articles is, it's been imperial from day one, which is completely antithetical to everything you and I ever learned about the foundation and formation of our government. It's always been imperial. No, it hasn't. That's why we left King George. I mean, I really don't understand that theory. And then you have people like Son Castine, who says, no, that's been a myth that's been used by out of control rogue presidents. And why MAGA and the GOP want this theory? Because what do they think? They're going to be holding the presidency for the next 100 years? More likely than not, they're going to lose the presidency in the next go around based on the first 50 days of this administration. Why would they want to empower President Gavin Newsom, President Gretchen Whitmer, President Pete Buttigieg with these powers? I mean, I don't really understand. This is the reason why history and tradition has
I'll tell you why, because they know they're not going to abuse it, Popok. The reason is
Democrats won't.
Correct. That's why the corporations feel fine to be like, oh, we know that if Kamala wins, then she's going to treat us fairly.
I think that's a dangerous proposition to hope that the Democrats are reined in.
That certainly is the world.
All right.
They don't for a second believe that the Party for Democracy, the Democrats, will do these things, and they know that the Republicans will, so they treat them differently. That's part of the problem.
But I wouldn't bank on that. And there's a reason why. And for instance, in this case, in 95 years since the founding of the National Labor Relations Board, no president has ever removed a member of it. They serve 5-year terms. Gwen was on her, she's a great labor lawyer and member of that. She was the chairperson. The president is allowed to remove the chair, and he did that. He's just not allowed to remove the person, the federal officer confirmed by the Senate, without cause and without due process. You can't just send her a thank you for your service email, which is what he's been doing to get rid of these people. And the unifying common denominator of the 3 cases, and I'll go back to a quote from Beryl Howell in a minute, the 3 cases that all came at the same time, all are the assault, the full frontal assault on federal workers by Donald Trump. One case removing the head of the Merit Protection Service Board, one removing the head of the Office of Special Counsel, and the other one, the National Labor Relations Board. The 2 were created in 1978 to protect the civil servants from partisan attacks and retaliation and whistleblowing retaliation. And the other one was formed in 1935 because of the violence in the streets against workers and unions, needed a independent, quasi-independent judicial body that was created by Congress in 1935. The interesting thing about, so all those 3 cases, they all fundamentally turn on one particular case, really, also from 1935, called Humphrey's Executor, which stood for the proposition that a president, in this case Hoover, couldn't fire a person like Gwen Wilcox, who was then on the board of the Federal Trade Commission, couldn't fire a Federal Trade Commissioner. And there was rationales related to that, the independence, the bipartisan, the very small amount of executive powers being exercised, and the will of Congress and precedent. And that's the case that gets cited over and over and over again. It's been reaffirmed by the Supreme Court 4 different times, including a version of it in 2020. That's the case, right? And so we've got this week alone, in the last 7 days, 3 different judges, this being the last one, taking on that issue. Amy Berman Jackson, Rudy Contreras, and now Beryl Howell, all uniformly saying Humphrey's executor stops Donald Trump from firing that person this way. The most compelling case is the one that Beryl Howell is talking about, because the NLRB, which Gwen Wilcox, the plaintiff here, is a part of, was formed 2 months after the Humphrey's executor case was issued by the Supreme Court. So of course the Congress knew about the Humphrey's executor case and created a board in its shadow. So that, I think this is an easy one. The weird thing that's happened, though, and I want to do one quote from Beryl next. The weirdest thing that's happened is that a 3-judge panel that you and I touched on, and I did a hot take on, of a Obama, a Biden, and a Trumper got together on the DC Court of Appeals, and they actually overturned Amy Berman Jackson, and they found that Hampton Dellinger needed to fight back for his job. They took him out of his chair as the head of the Special Counsel's Office, which protects federal workers, and said, no, you do your appeal, we'll do it over the summer, but you're out of a job until then. And he threw in the towel and said, you know what, 4 months or more of me being out of a job is with Trump, a Trump person in there destroying everything, is not, I'm not going to do this appeal. For what reason? Understanding there were other 2 cases, but we have a bad decision by the DC Court of Appeals on one. The other 2 cases, including Beryl Howell's, will go up to their own 3-judge panels and then over to the U.S. Supreme Court. She's speaking to the U.S. Supreme Court here, beyond the DC Court of Appeals. And when she said, I just want to read this one part, about the king versus the dictator. You did that part, but here's the part that I liked, among many. When she quotes Louis Brandeis, she says, as Justice Louis Brandeis, the first Jewish justice who eloquently opined, checks and balances were established in order that this should be a government of laws and not of men. Observing further that the separation of powers was not adopted to promote efficiency, but to preclude the exercise of arbitrary power. The purpose was not to avoid friction, but by means of the inevitable friction incident to the distribution of the governmental powers among 3 departments, to save the people from autocracy. She goes on to say on page 5, luckily the framers, anticipating such a power grab, the one that she's observing with Donald Trump, vested in Article 3, not Article 2, the judges, the power to interpret the law, including resolving conflicts about congressional checks on presidential authority. The president, Trump's interpretation of the scope of his constitutional power, or more aptly, his aspirations, is flat wrong. And she has now set this up. And who's in this tug of war on the Supreme Court between the Kavanaugh, Gorsuch, Alito, and Thomas, who are firmly in the unitary presidential model camp? What is Roberts going to? This is the time now for Chief Justice Roberts and Amy Coney Barrett to step up at a moment of history. Certainly Roberts has shrunk under the weight of history. As he's going down the history as one of the worst Chief Justices we've ever had. But what's he going to do now? He created this Leviathan, this out-of-control Frankenstein, in his immunity decision from last summer. And now he's got an opportunity on the civil side. And they know. And if they want to poke the bear, I said with Dina Dahl the other day, they poked the bear twice. They literally poked John Roberts at the joint session, which I think annoyed him. And they poked him in their filing, which Beryl Howell pointed out, because they said the basis for their unlimited, limitless, absolute presidential power grab is the immunity decision giving him criminal insulation, but doesn't talk about civil limitations on congressional checks. So, but you see, that's what when we see John Sauer one day, the former criminal appellate lawyer for Donald Trump, now our Solicitor General, arguing this, you know they're going there on immunity, and that's going to trigger, hopefully, John Roberts to do the right thing. Welcome back. If you know all you need to know about Legal AF, we are an hour-long podcast every Wednesday and Saturday for the last 5.5 years, one place on that dial, and we're on the Midas Touch Network. And we do intersection of law and politics show, 4 or 5 topics. Wednesday, I do it with Karen Friedman Agnifilo. Saturday with Ben Meiselas. Do hot takes about every hour right here on Legal AF and on the Midas Touch Network. Join us if you haven't already. Join us. Join our full-length podcast any way you like to get podcast, audio or video. Or you get these clips here that we do right after the show is over here on Legal AF. And if you don't know about, if you know everything you know about us, thank you for being part of our audience. If you don't know about us, now you know the way to join us. So until my next reporting, I'm Michael Popok. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories, the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.